Welcome to the Mandamus Lawyers Podcast, a legal education series about federal court remedies for immigration delays. I'm Mary, and I'm here with my co-host, Aaron. Today, we're addressing an important timing question. When is it too early to file a mandamus lawsuit?
This is a question that comes up frequently. People are frustrated with delays, they learn that mandamus is an option, and they want to know if they can file now or if they need to wait longer. The answer isn't as simple as a specific number of months or years.
We're also going to cover a relatedness conception, the idea that USCIS posted processing times determine whether a delay is unreasonable. Many people assume that if their case is within USCIS's stated processing window, they can't sue. And if it's outside that window, they automatically can.
That's not how it works. Courts make their own determination about whether a delay is unreasonable, and USCIS processing times are just one factor, not the defining standard. Understanding this distinction is important for evaluating when to file.
Let's start with the basic question. Can you file a mandamus lawsuit too early?
Yes, filing too early can result in the court dismissing your case. If the delay isn't long enough to be considered unreasonable under the legal standards, the court will likely side with the government.
What happens if a case is dismissed for being premature?
The court grants the government's motion to dismiss, and your case ends, at least for the time being. You've spent time and money on litigation that didn't succeed. You could potentially refile later when more time has passed, but that means starting over.
So timing matters strategically.
It does. You want to file when your case is strong enough to withstand a motion to dismiss. Not so early that the court views the delay as reasonable given the circumstances.
Is there a specific waiting period, like 1 year or 2 years, after which you can file?
No. Courts have consistently declined to establish bright-line rules. They won't say that any delay over 12 months or 24 months is automatically unreasonable. The analysis is fact-specific and depends on the circumstances of each case.
Why don't courts set a clear threshold?
Because different types of applications involve different levels of complexity. A straightforward green card renewal is different from a complex EB-5 investor petition. A naturalization case where the applicant has already completed their interview is different from an asylum case requiring extensive country conditions research. One-size-fits-all rules wouldn't account for these differences.
So the question isn't just how long you've been waiting, but what's reasonable given the type of case?
Exactly. The track factors we discussed in Episode 5 provide the framework. Courts look at whether the agency is following a rule of reason, whether Congress provided a timeline, the effect on the applicant, competing agency priorities, the interests at stake, and any evidence of bad faith.
Let's address the processing times issue. USCIS publishes estimated processing times for each form type. Don't those define what's reasonable?
This is one of the biggest misconceptions in mandamus litigation. USCIS processing times are the agency's own estimates of how long cases are currently taking. They are not legal standards that define reasonableness, and courts are not bound by them.
Can you explain that further?
USCIS processing times are backward-looking. They show how long it took to complete a certain percentage of recently adjudicated cases. They're descriptive statistics, not legal benchmarks. The fact that USCIS says a particular form is taking 24 to 36 months doesn't mean a court must accept 36 months as reasonable.
So if USCIS posts a processing time of 40 months, a court might still find a 30-month delay unreasonable.
Potentially, yes. Courts conduct their own analysis. They might look at that 40-month estimate and conclude that it reflects systemic dysfunction rather than reasonable processing. The agency cannot immunize itself from judicial review simply by posting longer and longer processing times.
How do courts actually approach this question?
Courts apply the track factors independently. They consider whether the agency's timeline follows a rule of reason, not just whether the applicant's wait time falls within the agency's posted range. A court might find that even if an applicant is within USCIS's stated processing window, the delay is still unreasonable because of the specific circumstances.
What circumstances might lead to that conclusion?
Several things. If the applicant's case has been pending significantly longer than similar cases filed around the same time, that raises questions about whether the agency is acting rationally. If the applicant has experienced severe hardship, family separation, job loss, inability to travel for emergencies, That weighs in favor of finding the delay unreasonable. If the agency has simply ignored the case with no activity whatsoever, that's different from a case where there's been ongoing review.
So posted processing times are relevant, but not controlling.
Correct. They're one data point among many. Courts have explicitly stated that agency-posted processing times do not define the legal standard for unreasonable delay.
Are there situations where USCIS processing times are useful in mandamus cases?
Yes, in two ways. First, if your case has been pending significantly longer than the posted processing time, that supports an argument that the delay is unreasonable. Being outside the agency's own estimates strengthens your position.
And the second way?
Second, dramatic increases in posted processing times can themselves be evidence of systemic problems. If USCIS previously processed a form type in 12 months and now posts 48-month estimates, that doesn't mean 48 months is reasonable. It might mean the agency has failed to allocate adequate resources to meet its statutory obligations.
So applicants can use processing times as a sword, not just a shield.
Exactly. The argument becomes, even by the agency's own admission, this process is taking far longer than it should, and courts should not defer to timelines that reflect bureaucratic dysfunction rather than legitimate processing needs.
Let's get practical. What factors suggest it might be too early to file?
Several indicators. First, if your case is well within normal processing times for that form type, and there's been regular activity, biometrics taken, requests for evidence issued and responded to, interview scheduled, the agency may be actively working on your case. Courts are less likely to find delay unreasonable when there's evidence of ongoing adjudication.
What else?
Second, if the delay is relatively short, say a few months beyond the typical processing time, and you haven't experienced significant hardship, the case may be weaker. Courts balance the length of delay against the impact on the applicant and the agency's need to process cases in an orderly fashion.
Any other factors?
Third, if there's a known reason for the delay, a pending background check, for example, and that reason is legitimate, courts may be more deferential to the agency's timeline. That doesn't mean you can never file, but it affects the strength of your case.
What factors suggest the delays become unreasonable and it's time to file?
Several things strengthen a mandamus case. First, significant time has passed with no activity on your case. Not just a few months, but extended periods, often a year or more beyond typical processing, with no indication the agency is working on it.
What else indicates readiness?
Second, you've made efforts to get information or resolution through administrative channels, and those efforts have failed. You've submitted inquiries, contacted your congressional representative, perhaps used the ombudsman, and nothing has moved the case forward.
Are there other factors?
Third, you're experiencing concrete harm from the delay. Family separation, inability to work, missed career opportunities, financial losses, inability to travel for emergencies. The more specific and documented the harm, the stronger your case. Courts weigh the human impact of delay heavily in the track analysis.
Are there any immigration contexts where the timing question is clearer?
Yes, some statutes provide specific timelines that strengthen mandamus cases. The clearest example is naturalization under Section 1447B. If USCIS fails to make a determination on a naturalization application within 120 days after the examination, the applicant can apply to the district court for a hearing on the matter.
So for naturalization, there's an actual statutory deadline?
There's a statutory timeline that triggers federal court jurisdiction. If you've completed your naturalization interview and 120 days have passed without a decision, you have a strong basis for filing. That's different from most other immigration applications, which lack such clear statutory benchmarks.
Are there other examples?
The I-829 petition for EB-5 investors references a 90-day period, though, as we discussed in an earlier episode, this timeline is tied to the interview stage and becomes disputed when interviews are waived. It's a contextual benchmark indicating congressional intent for prompt adjudication rather than a fixed deadline. But it still provides useful support for arguing that extended delays are unreasonable.
How should applicants think about the timing decision strategically?
It's a balancing act. File too early and you risk dismissal. Wait too long and you've suffered additional months or years of delay unnecessarily. The goal is to file when the case is strong enough to succeed, or at least strong enough that the government will likely choose to adjudicate rather than litigate.
How do you find that balance?
Work with an experienced attorney who can evaluate the specific circumstances of your case. They'll consider how long you've been waiting, what type of application is involved, what activity has occurred on your case, what hardship you're experiencing, and what the case law looks like in the jurisdiction where you'd file.
Is there a general range where cases tend to be strong?
Patterns vary by case type and jurisdiction, but many practitioners find that cases pending significantly beyond posted processing times, often a year or more beyond, with documented inactivity and hardship, tend to be strong candidates. But this isn't a rule, and individual circumstances matter enormously.
What if someone isn't sure whether their case is ready for litigation?
Consult with an attorney who handles mandamus cases. Many offer consultations to evaluate whether a case is viable. They can assess the length of delay, review the processing history, discuss the hardship factors, and give you a realistic assessment of timing.
Should someone wait until they're absolutely certain the case is strong?
There's no such thing as absolute certainty in litigation. Every case involves some risk. The question is whether the case is strong enough that the likely benefits outweigh the risks. An experienced attorney can help you make that judgment based on similar cases they've handled.
And if the attorney says it's too early?
Then you have a choice. Wait longer until the case is stronger, or accept a higher risk of dismissal. Some applicants choose to wait. Others decide the potential benefits justify the risk. It's a personal decision informed by legal advice, not a decision the attorney can make for you.
Let's summarize the key points from this episode.
First, it is possible to file a mandamus lawsuit too early. Courts conduct a fact-specific analysis to determine whether a delay is unreasonable, and filing before the delay is legally unreasonable can result in dismissal. There is no magic number of months or years that automatically qualifies. Timing depends on the type of case, the circumstances, and the track factors.
Second, USCIS posted processing times do not define what is legally unreasonable. These are the agency's own backward-looking estimates, not legal standards that bind courts. A court may find a delay unreasonable even if it falls within USCIS's posted range, and conversely, may find a delay reasonable even if it exceeds that range. Courts make independent determinations based on all relevant factors.
Third, factors suggesting a case is ready for litigation include extended delay with no case activity, failed attempts at administrative resolution, and documented hardship. Factors suggesting it may be too early include relatively short delays, ongoing agency activity on the case, and absence of significant harm. An experienced attorney can help evaluate timing and make a strategic recommendation based on the specific circumstances.
Thank you for listening to the Mandamus Lawyers Podcast. Mandamus Lawyers is a law firm focused exclusively on federal court litigation for immigration delays. Visit mandamuslawyers.com.